Hello, everybody. This is Chamel Kusugal. I would like to welcome you to the webinar on impact of GDPR on the International Criminal Code. This webinar is brought to you by Vivek, Content Management Manager in Special Interest Group. And this is led by Dr. Jones Lucas. If you're not a member, I would definitely recommend you to go and sign up. If not already a member, on the link that's been on the slide, presented on the slide. This is hosted by me. I'm Chamel Kusugal. I'll be the moderator and the host for this webinar. I'm a Vivek member and a leader in Security and Data Privacy Special Interest Group, and I'm based out of East Coast, US. I've been in the industry for the last 18 years, and I'm working with large global enterprise customers to deliver solutions in QA, automation, and cloud technologies. Incidentally, in the past, I used to work for Mercury and HP. But currently, I founded my company called as Oster Technology Services, where we work with large enterprise customers in digital transformation projects. Today's speaker is Dr. Jones Lucas. He's the Information Management Officer for the International Criminal Code. Dr. Jones Lucas has been very experienced and been in his profession for quite a number of years, and he's currently he's responsible for the design, implementation, and maintenance of integrated digital repositories for the code. He's a senior information management practitioner with almost 20 years of national and international experience in developing and implementing strategies to achieve operational effectiveness and regulatory compliance by leveraging ICT. He holds a BSc in Electronic Engineering, MSc in Organizational Development, and also PhD in Computer Science, and apart from also having an MBA. So that's quite a pretty good credentials he has. And that's about the presenter today. Some housekeeping, webinar housekeeping. This is a live session and it's being recorded, and all these recordings are available to all the Vivek members. For those who could not participate in the live, they can view this later at their convenience. About this content manager, there's a webinar control panel. For Q&A, you can click on the language and you can type in your questions. At the end of this presentation, we'll try to answer most of the questions that's been asked by the participants. And you can also select different language to ask the questions. Definitely we'll try to answer them as we get them. So without much ado, I'd like to hand it over to Dr. Jones Lucas to take us through this presentation. Thank you. Dr. Jones.
All right. Thank you very much, Jamel, for that introduction. I think it prepares me very well to tell the story that I'm prepared to say this afternoon. I will start by just sharing something that I experienced a number of years ago while working for a sister international criminal court in Africa, in particular the tribunal that was responsible for trying the crimes against the people of Rwanda, where genocide occurred. I happened to be one of the information specialists working in the court when they were trying those cases. I remember very clearly in one of the cases we had a witness who, in the event of the genocide during the period, he was able to see the atrocities being perpetrated against the people of Rwanda. Next to his living quarters, there was a church or a building that had hosted a number of people that were running away to get shelter from the perpetrators. And he was able to see the perpetrators arrive and kill the innocent civilians that were in the church at that time. So this was one of those we call very material witnesses. And of course, he was invited in the courtroom to detail or to describe his story. Of course, as part of the judicial process requires parties to engage, and the witness is also examined or cross-examined. So one of the days, as he had finished his first testimony, he traveled back home and was scheduled to come back again in a couple of days to continue with his testimony. Now, it didn't take more than 7 days before I received a phone call from my supervisor that said, "Hey, Jones, we have a problem." It was early in the morning, and I said, "What problem do we have?" He said, "I cannot tell you on the phone. Please come to my office." So I ran, falling down and waking up, to his office. And he told me, "Jones, we have a situation. One of our witnesses has been assassinated." It was the first time in my professional career that I had experienced something as drastic as this. A witness that I had met face to face, that I had helped to prepare in terms of providing the systems and the solutions that would enable him to be cross-examined effectively in the courtroom. So I was devastated. I asked myself, how could this happen? Apparently, what occurred is that he was assassinated in an attempt to prevent him from completing his testimony. And with that story started a journey for me that has been very peculiar, at the same time very interesting and very challenging. Because the work that I do or help to do within the international criminal justice is fraught with challenges such as this. A witness that is supposed or meant to be protected is assassinated because information has leaked out to perpetrators on the name, or the identity, the location of such a witness. And you can see this is where it starts the story of privacy and protection within the tribunals or courts such as the one that I work in. So I decided that in my professional capacity, I will do whatever it takes to help advance the cause of international criminal law and international justice and human rights by playing a role my professional role within information management to make sure that such incidences don't happen again. So here I am now at the International Criminal Court in The Hague in the Netherlands. This is a court that is tasked to try cases or crimes against humanity. So we bring to trial those that have committed serious crimes, war crimes, genocide, those that enlist child soldiers in war, those that do harass or exterminate entire populations. Those are the individuals that we seek and bring to trial. As you can see, this is a very sensitive operation that involves many actors, many players. It involves a lot of information. It involves parties all the way from prosecution, the defense, the judges, and even the victims are allowed to participate in the judicial process. So then the question would be, how then does the new law, the Gdpr, affect institutions like the International Criminal Court? As you can see, it is very clear that the fundamental principle, which is the privacy of information, is respected whether or not GDPR exists or not. Privacy is a fundamental human right. So the International Criminal Court was founded long before GDPR came into effect, but the principle of privacy is still paramount. Now, to continue with this story, I will briefly just mention the work that we do from the dimension of information management. Our prosecutors go into the field to collect a whole range of information. This information is complex. It's of high volumes. It exists in different formats. Anything that can store information that would reveal or help the adjudication of a case would be collected. Could be on fridges, microwaves, TVs, computers, hard disks, servers. Any device, any interface, any platform that stores data that is relevant for the case will be looked at. So in this regard, the data collection process for us is a very distinct, a very important activity within the information management value chain within the criminal court. And then from there on, we have the data processing and then the data sharing. So I'll just dwell on each one briefly, and then at the end of the slides, I will conclude with how this impacts our standing within the GDPR law. Now, as mentioned before, when we do collect data, this data, we collect it with the aim that it could be presented as evidence in the courtroom. The ICC itself has been strategically established as an electronic court. So, of course, then it is quite obvious that the information that we receive is processed in digital form. And this is in form of materials collected, videos of exotic formats, maps, paper records, digitized, audio, visual, documents, databases, and all the sorts. Now, this data that's collected from the field is brought in, and then the judicial process is established or is initiated. Now, within the judicial process, there's also data that is created. And this data comes from the activities of the participants in the courtroom. You're talking about things like decisions, transcripts of what is going on, translations into the various languages that the participants or the victims speak. We also do audio and video recordings of every session and publicize this directly to the public so that they can consume from the various countries they are following the case from. So our data collection activity, as we look at it, involves data coming from the field and also data that is created and accumulated from internal processes. The bottom line is it's voluminous, as in tens of terabytes. The goal that we have is that any public information that is created or collected should be able to be processed and registered and passed through the pipeline within 24 hours. Now, this is a very tight time period that requires quite a lot of diligence and processing. This leads us to the stage where we do the internal processing of the data. Now, of course, we know that the litigation process can be quite lengthy. Some of our cases go up to 10 years. And the process of litigating through this requires quite a lot of data processing activities. So in the background, we do a lot of categorization of information, classifying it into various aspects. Of course, security is one of our pillars. The story that I just told before highlights the importance of designing our solutions using the pillar, based on the pillar of security. And in this regard, what we do is that even though the public have an obligation, or we have an obligation to publicize our activities to the public immediately, we are also tasked with the responsibility of redacting as quickly as possible, removing things like witness names, redacting location details that could allow members or evil or the perpetrators to intimidate victims and witnesses. And to do this, we use quite an extensive range of security and access management procedures. Now, this allows us, because what we do is that in this process, our main goal at the moment is to allow the litigants and the lawyers who are participating in the judicial process to do so efficiently and effectively, and to build a system of trust within the parties. Now, this leads me to the last segment, which I'm talking about, which is the data sharing part of it. Now, this is very, very extensive for us, because what we do is that whenever we have a courtroom activity, the public have access via the public website in real time. Actually, it is in near real time. What we do is that we have a 30 minutes delay where our lawyers and our specialists are able to examine all materials and the audiovisual materials that are going out to the public to see if they have been properly redacted or classified. This is again to make sure that private information, sensitive information does not leak out to the members of the public. And we trust that by doing so, we fulfill the mandate of the court where we are supposed to be responsive to the public when it comes to accessing the information that we handle, but at the same time safeguarding also the interests and the safety of the witnesses and the victims that come from all over the world. Our data sharing activities could be perhaps described in four main categories. There is the digital material content that is consumed via the public website. And these are decisions, submissions, court records that are public, that have been classified as public. These are automatically published from our internal systems to the website. The streaming of courtroom activities through video and audio is also done so that victims, witnesses, and other participants and those that are interested in the case from all over the world can be able to watch and listen in to what is going on in the judicial process itself. We do this in various languages in real time. So, for example, if we have trying a case from the situation of Uganda, we do translate also the materials, and we do translate the audio of the videos into the language of the participants that are following from the different countries that are affected in the case. Now, you can see this is quite a data-intensive exercise that requires a lot of coordination and orchestration. But at the same time, the question that we ask is, how do we do this promptly, quickly, deliver justice quickly, at the same time safeguard the important information that we are handling? This is an ongoing responsibility for us, because you can see technology changes, the actors out there are building or creating sophisticated means of breaching systems and getting access to data. So for us, this is an exercise that we are continuously adapting ourselves and evolving to the changes that are happening in the technology world, so that we can be able to maintain our obligation to protect the victims and witnesses. Now, I would just like to mention a few tools that we use within the pipeline. There are quite a number, but I'll just mention a few that perhaps would highlight how we manage and safeguard the information that we collect. Because we are a security-conscious organization, with the privacy and the protection of information being one of the key requirements, we have made it a priority that all our business records, all our judicial records would be managed via an efficient information and records management system. And that is the reason why we chose quite a number of years ago to go with the system you see, which is called the Enterprise Content Manager. Even then, when we started using it as a records and document management system, at that time it was called TRIM. And after various acquisitions and changes, it is now called the Enterprise Content Manager, supported by or sold by Micro Focus. Now, we use this as a central platform for records management. In other words, this is a tool that manages our security policies for judicial records, managing who has access to what particular record in which particular case. This is what we call the sole truth for access to records. So it is a layer within our system or within our enterprise that provides access to protected and sensitive material. Then we also have a tool we call Control Point. Now, the Control Point, we use it for analysis. I've talked quite a lot about, at the beginning, about the information that we collect. We ask ourselves, how can we be able to identify what is sensitive versus what is not sensitive? So Control Point is also a tool that is helping us, together with the other forensic tools that we have, to determine what materials are useful and how they can be classified efficiently, involving indexing in various forms: text, video, image, and speech. And then, of course, we've integrated our systems along the pipeline in such a way that our public website, which runs primarily on SharePoint, receives the materials that are public in nature, and these we are able to disseminate to members of the public all over the world. So, in a nutshell, these are the main tools that we use within the information management pipeline. Of course, in court like such as ours, we have specialized operations. For example, when you're talking about things like translations, we have specialized translation tools. When it comes to analysis of forensic materials, we have also specialized forensic solutions. Those I haven't mentioned specifically, just to highlight that each stage has got specialized tools, but these are the main ones that perhaps would be most important for our discussion today. So then, you would ask, how does GDPR impact the International Criminal Court? I think it's a very fundamental question. We've had plenty of debates internally on whether or not the International Criminal Court needs to comply with GDPR. Now, the good news is that because we built our systems and our processes around the fundamental principle of privacy and protection, so in our own DNA, I would say, we have adopted the principles that GDPR as a law tries to disseminate. The principle of protection of information that identifies persons. This is built in within our own systems. So even though as an international criminal court, we are supposed to be independent of national and regional laws, in a way we are impacted. We're impacted because we also deal with organizations and intermediaries and parties that are subject to the law itself. So even though some of our debates, some individuals concluded that perhaps we don't need to comply with GDPR, but it is very clear that GDPR itself impacts the International Criminal Court in a way. Just the fact that we exchange information with third parties, we collect information that could identify EU citizens. It means that we have to try as much as possible that we don't breach this law. Well, the good news is that our operations are already built with that principle. So we thought it's very interesting as ICC as a case when it comes to GDPR implementations, because many organizations today are suffering or are freaking out, asking themselves, how can we reorganize or set up ourselves so that we can be able to comply with this humongous law that has far-reaching effects? I think for us, it's our responsibility to say good news, to say it is possible. It is very possible, because the very principles of data privacy and protection of persons, we have experienced it as part of our ongoing obligations to run the court. So we stand also as a case, even though we do not directly come under the law, but we are a player in this ecosystem. And being a player in the ecosystem, it is important that we're able to integrate, especially when it comes to data flows, with other intermediaries and other organizations that work with us. So I just would like to say that the law itself is a very intriguing piece of legislation. It has far-reaching effects. There are various questions we're asking ourselves, even internally. Some of the discussions are still ongoing, but the comfort that we have, that we can give, is that the fundamental requirements of GDPR, of the law itself, are already fulfilled in the processes that we have established within the courtroom. And we have said that even though we are ready to learn from other organizations also and other entities as they embark on this journey, we are also prepared to share our experiences along the process, some of our failures and some of our successes. And in this regard, definitely I would like to thank you all also for joining in and listening to this story. As brief as I have presented it, I hope that it gives you not just hope also, but it also gives you that assurance that there are organizations around that have embarked on this journey and have succeeded while fulfilling the very mandate they were created to do. So thank you very much, and I'll open up for any questions at this stage.
Wonderful, Dr. Lucas. It's been a fantastic presentation, showing us some insight about how data is managed within an independent organization like International Criminal Court. Before we start some questions, let me once again remind the participants that the GDPR regulation, when in effect on May 25, 2018, will replace the 1995 Data Protection Directive of the EU. GDPR will address the export of personal data outside the EU. It aims to give control back to the users over their personal data and regulate the usage of private data by international businesses. This can definitely have a huge impact on the collection and storage of private information by businesses and other entities who harness private information. So this presentation by Dr. Lucas tries to explain how some of the entities, like international entities like ICC, handles the private information. Here's some of the popular questions that I would like Dr. Lucas to answer us. The first question coming up is how does the ICC handles private information, privacy data in its operations? Are you therefore subject to the compliance requirements of the law? And when can your staff be liable to sanctions? Very interesting. I would like to get some insight from Dr. Lucas on this.
Yes, that's a question that has been subject to quite a bit of debate. But it is more or less settled because the International Criminal International Criminal Court was established via a statute, what we call the Rome Statute. And it was established as an independent court that needs to be seen as not just independent in terms of the way it does its operations, but also independent in where it derives its jurisdiction and also its legal rules and procedures. So in essence, we are not necessarily obliged, we're not bound by the Gdpr law per se. Our staff have immunities when they are working for the International Criminal Court, and in this regard, then they are not personally liable to activities that they conduct on behalf of the International Criminal Court. However, because we do work very closely with local, regional firms in various capacities, I've just mentioned, for example, a public website is hosted by an organization that is subject to the GDPR law because it exists and is established and has operations in Europe. So it's very important that for us we assure ourselves that not only our companies that we associate with, that we work with, comply, but also our internal systems are adapted to fit into the flow of information as required by the GDPR. Otherwise, if we don't do so, I think for us it brings risks and also it introduces costs, huge costs, costs with interfacing, costs with protecting data, costs that prevents us from efficiently outsourcing operations that we need to outsource. So for us, even though we are not bound, it's important that we set up ourselves to comply.
Okay, thank you, Dr. Lucas. Here's another question from our participant. What practical changes still need to be done to your data processing, example, to enable you to quickly identify and isolate all copies of all personal data relating to EU?
Right. I think one of the most challenging aspects of our data processing activities is the prevalence of exotic material. When I say exotic, is data that comes in the form of audio-visual in various formats. Some of the formats are proprietary. Now, when it comes to the identification of sensitive and private information, that becomes a very tedious exercise for us. And we are hoping that in the due process, we will continue to evolve to develop our processes and also adopt technologies that are more efficient when it comes to identifying materials that are sensitive within the exotic materials that we collect. So that's one process that we think that we still have some room for improvement. Now, the other area of improvement is being able to now design interfaces, external interfaces that are GDPR compliant, where we share information with intermediaries and organizations in Europe and across the world. So that's an ongoing process, and what we're trying to figure out is a framework that we can use that not only complies but also provides efficient transmission of information between ourselves and intermediaries. One example is we have relationships with universities that are doing research and so on that consume also a lot of our data. We want to ensure that when we do so, when we create these interfaces for them to link and consume data, that we're able to assure ourselves that they are also compliant, at the same time that the data that they receive is channeled through procedures that follow the requirements of the law.
Very good. That definitely is reassuring. Here's another question. What internal actions are being taken to update documentation, policies, procedures, and process, as well as training of staff on how to handle personal data to comply with this law?
Right. We had already started quite early on with the internal awareness activities and campaigns within the organization to train and also make staff aware that they are responsible for the privacy and protection of data that they handle. And this is an area that we have recently ramped up and is driven very closely with our information security team, that is making sure that every staff knows their responsibilities, that every staff is aware of the areas where breach could occur, and also the consequences that could cause that. So we are doing various activities, including also induction programs for new staff when it comes to information security. We are also applying it across the domains that we work with, so that all those partners that engage with us are also made aware that the privacy and protection of data is one of our core principles. So in terms of procedures, this is an ongoing activity. We are constantly scanning technology to check for vulnerabilities, especially when it comes to digital content. We are a court that exists as a digital, as an electronic court, so it's very important that we continuously examine the effects the new technology is bringing and the risks that could ensue as a result.
Okay, thank you, Dr. Lucas. Here's another question from one of the participants. He would like to know what study guides do you recommend to get more knowledge on knowledge of GDPR? You can share some of your sources that you were able to get more information and be prepared for this regulation. This can help the participants.
Yeah, this is a very, I think at the moment I must agree that it's a very confusing period for those that are planning to understand and implement or comply with this law, because there are various people or organizations out there that purport to provide GDPR toolkits. I think the advice I would say is that people should not be duped into following blindly in adopting or purchasing toolkits that claim that would make them GDPR compliant. I think the advice I would give is to go back to the basics, to examine the principles behind GDPR. What is GDPR trying to achieve? And once that is understood, then go back to their internal systems and look at ways in which they can re-engineer them or re-engineer their processes so that they are built already with privacy in mind. So in this regard, I think it is very important that the teams that are examining this create a very close and tight coordination between the information management, the IT, and the information security teams. These three providers, what I would say service providers, internal service providers, need to be in sync. While at the same time, the businesses need to ensure that when they are complying with the GDPR, that they are not overly reliant on technology. The process itself needs to make sense. I can give you an example. One of the requirements within the courtroom is that if a lawyer is discussing about a witness, the lawyer needs to be aware that in public session, he or she should not say or reveal the name of a protected witness. You cannot solve this using systems. You have to train and teach people. So I think it's very important to go back to the basics. And once one examines the basics, and then from there, I think it will be very easy to find materials and resources to assist.
Wonderful, Dr. Lucas. I definitely like to add on to that. There is tons of material available on GDPR online, but some of them can definitely be misleading, as you rightly mentioned. So it's pretty important for people looking for that information and regulatory compliance guidelines to go back to the basics and validate that before trying to validate their applications for GDPR compliance. So that can be a little bit tricky if you are not following the right source. So it's pretty good advice. I think there are some questions coming up. I would like to, lack of time, I would like to move on to the next. And we definitely like to thank you for the fantastic presentation and also answering some key critical questions that's been raised by participants. So let's move on to the next slide. Just for information of all the Vivek members who are participating, there's board elections coming up, and here's an update. So it's the board elections will run from April 2 to May 2. We're almost closing now, so I would definitely say to you for everyone to participate and vote for the different candidates who are contesting these elections. There are 5 open seats for 3-year terms, 1 2-year terms, and 1 for 1-year term. And there are the list of candidates on your slide. So please log on to the Vivid website, and you should definitely see the selections. And it will be wonderful if you all participate. Some of the next upcoming Vivid webinars, we have a special interest group talk on IT operations, especially on Sitescope and OMI. This is on 8 to 9 a.m. Pacific time, and 11 to 12 Eastern time for US, New York time. And for the CET, it's between 5 to 6 o'clock in the evening here, Frankfurt. Here's a link, so you can go and register here. So thank you very much, everyone, for participating in this webinar. And once again, I'd like to thank Dr. Lucas for this fantastic presentation. And here's Paul coming up for all the participants. If we get a chance, just answer this poll and survey, which is going to help us to make this webinar sessions better and coming better and meaningful in the next presentations. So we definitely will like to hear from you by these polls and surveys. Fantastic. I'd like to thank everyone and have a great day.
Thank you very much.